I don't know why laptops are slower than phones, but you see the laptop one is going on now, but maybe I should just cancel it so I don't have echoes and stuff. So I want you to enjoy this course. I keep saying to you, and we ask ourselves the question whether we've asked ourselves the questions earlier on. What is law? We've asked ourselves earlier on how jurisprudence equips us with investigative powers to know what's going on in terms of the nature of things. It goes to the heart of things. We know we've tried to distinguish the fact that science would be primarily a question of going to the laboratory, observation, experiment.
Recording in progress.
I'm trying to switch it off and stick to the phone. Lovely. Okay. Yes. What else was I saying? Yeah, and I also mentioned the fact that science basically is a body of discovery, intellectual and practical acts. We're looking at the structure, behavior of the physical and natural world. We're trying to measure things in the laboratory. So let me move on now to whether law is a science. So would you consider law a science? There's a lot of debates as to whether law is a science or not. And some of you may agree or disagree as to whether law is a science, because law applies to human beings and not to animals. So what do you consider law? What is law? We tried to mention what law is in the earlier class, and I think we came to the view that there's no agreed definition as different philosophers have looked at it from different angles. The fact that law is descriptive of relationships is something that we touched upon. So how do we now determine whether law, as we're talking about, is a science? So is law a science? Is a question that has been asked. And I think what we're really talking about is that what is the nature of law? That's what is the nature of legal knowledge? What is its actual nature? You see, I always come back to nature. Achubu Mesoma. Achubu Mesoma, are you in class? Achubu Mesoma, are you in class? Badebo Damilola, are you in
Yes,
class?
sir. I'm in class.
Why is it taking you so long to answer? You're supposed to
I
be
was
next to your phone.
trying to connect my audio.
Now, when I say nature, what does nature mean? Nature. What is the meaning of the word nature?
Um, the nature is like the innate characteristics of something.
The inner characteristics of
Innate,
something. Innate.
yes.
And are you saying it from your head or are you looking at it online?
It's in my head.
How will I believe this now? Okay. So when you're talking about nature, you're not looking at the body. You're trying to go to the heart of the matter. Is that what you're saying? The inherent character. What does it constitute of? What is it really about? The fundamental character of something. Abi? So what is the fundamental character of law as a knowledge in which we will now call it, whether we now determine the question as to whether it's a science or it's not a science. So, but what do you mean by science? You see, at each time when we say ask these questions, we have to also ask ourselves, what is science? So I was mentioning the fact that law itself not necessarily it's has no agreed definition per se. Different philosophers have different views. Scientific laws at looking at the relationships between things or phenomena. And when you look at law, you are prescribing how people should behave. Usually, do not steal, do not drive on a one-way street in the wrong direction. So we're trying to look at, most of our lawyers are more concerned about how behavior and what's happening basically in the world. So they may regard law as an analytical type subject, but this subject is also trying to prescribe how we ought to behave. How do we ought to behave linked to morality, linked to religion, linked to other things like that. So in this context, what is science? Science can be considered a systematic body of rules or even knowledge in which we use observation, we use reasoning, and we look at we look at underlying principles. That's the older view of what science is. But you can also look at science in a more modern context where you look at more narrowly as is empirical work, is experimental work that gives us knowledge. So you can see that separation between the older view of what science is, the classical view of science, and the more modern, more narrow approach. So whether law is a science or not will now depend on what do we consider to be science. As part of scientific methodology, we know that we start from a hypothesis, you do your experimentation, you look at how things are working in the real world based on a theory, and then hopefully you could, through a process of experimentation, you can either validate the proposition or you say that this proposition does not work. So you can even do a PhD, for instance, in science, where all you have done is to say that if we apply this method to curing cancer, it will not work for these reasons. And that closes off an avenue. So other scientists don't have to go and repeat those experimentations and those, and all the work you've done in that area. So we are looking at different permeations and different ways of doing things. Are we together?
Yes, sir.
Yes, sir.
Thank you very much. So you see, that's one of the reasons why you see that in the scientific community, they get very angry when people are falsifying data. When you falsify data, it means that when people try to do the experiment you said you did and you got to this conclusion, when they did it, they could not get to that same conclusion because you falsified the data. And that creates problems for humanity in a way because we rely on other people's experimentation to add to the body of knowledge. So other people will not go through that route that you say there's no road there, not knowing that you didn't do the work properly and you falsified all the data. Or you said, oh, I got a positive result, when anybody repeating that same experiment 1,000 times all got negative results. Okay. Now, that classical view of science, as I was saying, as law as a science, you find that in the 19th century, jurists like John Austin and Hans Kelsen viewed law as a science. Austin, Kelsen, they view that law is a science. What does this mean? Law is a science because law provides systemic and rational, and provides a rational body of rules. It's systematic and it has a rational body of rules. So that's the view of John Austin and Hans Kelsen. Okay. Now, when you're talking about John Austin, is looking at basically analytical jurisprudence. He called jurisprudence the philosophy of positive law. If you remember from the previous class, what did I talk about when I talk about positive approach to law? Positivity. We're looking at law as an autonomous system. Law is there regardless of morality or politics, whatever. Law has no linkage to morality. It's just a rational body of rules, and it's on its own, so to speak. Yeah. So for him, John Austin, you could study law scientifically by analyzing concepts. If you analyze those concepts logically, that is law. So that's science. Just as you might study, I don't know, geosciences. What's a right? What's a sanction? What's a duty? You know, all these things make a pop up in law all the time. So when you look at Kelsen, though, Hans Kelsen is the one that wrote that determined the pure theory of law. So look up Hans Kelsen. Okay, Hans Kelsen is now arguing that yes, law is a science. It's not just a science; it's a pure science. And law is a science that should describe legal norms logically and systematically without consideration to societal values, to morality, and so forth. So that's from that positive school, as we've said in the past. And he wanted to basically make law a subject that is free from values, which, in other words, you can study law objectively, the same way you can, I don't know, dissect a cockroach in the lab and study it objectively. His aim is to make law objective and value free. Just like natural sciences, all you do is describe facts and not add your own and color it with your values or color it with your your judgment. Are we lost or are we good? Are we okay?
Yes, sir.
Yes, sir.
The same people are okay, but many people are not okay. But
We're okay, sir.
Itohon Eworo. Itohon, are you in the class?
Yes, I am, sir.
So Itoro, why do you believe that? Do you agree with the positive school who are saying that law is on its own? It should not be considered in a value from the view of our own morality or societal concerns or politics. Law should just be allowed to be law, an objective body of rules that is the same thing as if you are doing an experiment in a laboratory. Do you buy into that?
No, not really, sir.
What do you buy into?
Yes and no, honestly, and I'll say for both reasons. No, because every society, every culture is different.
Okay.
No, because every society and culture is different, the law ought to take that into consideration, right? There's a theory, I think, that the Constitution or the law is made by constituent power, and the Constitution is not the ground norm, but the constituency is actually the ground norm, since it's the culture that makes the law, right? However, when you go to some societies, I think there's some people that don't believe that murder is a bad thing. So in that case, it wouldn't be bad.
What society do you know of that? What society do you know of that? Murder is not is a good thing. Nobody wants to die now.
Some what they call this, kind of like rural or
anarchist society. I'm
yeah,
not aware of any
anarchist societies or
really
cultures where it's normal to maybe sacrifice your kid or something like that, or female genital.
Okay,
exactly.
fair enough. But
so in that case,
have you considered that those kind of societies where maybe they kill the twins or they do human sacrifices or whatever, that they have a different approach to morality. Not necessarily they don't have morality. That same
Yeah.
society may think it's perfectly normal to marry your daughter. In their own society, that could be a moral thing. When in other societies, that's completely out of order and not acceptable. So anyway, that's a very interesting point. You find that there are schools, like you said, that say that law is not a science. Okay, law is not a science. If you look at the sociological jurisprudence of Eugene Ehrlich, Roscoe Pound, there's arguing, as you are saying there, that law is actually a social phenomenon. I know it's not a logical system. You cannot look at law in a laboratory and everything is just objective and rules based. No, it's actually a social phenomenon. It's law is found, as you are saying, in how people behave, not just even in the written laws. The written rules are not enough. The behavior of people determine and drive what real law is. So therefore, according to this sociological school, sociological jurisprudence of Eugene Ehrlich, Roscoe Pound, and so forth, they're saying that law should be studied like a social science. Like a social science. We should view law like a social science through observation of how law operates in practice. Does that make sense? We don't look at
Yes,
it in the
sir.
lab.
Yeah.
We look at it in the real world, how it actually operates in practice. Also, look at the legal realism school of Carl Lewin and Oliver Wendell Holmes. Carl Lewin and Oliver Wendell Holmes are from the realism school, legal realism. They say that law is actually not what the statute books say. So if I want to know about the law, I'm not just going to look at karma and say, this is the law. Instead, law is actually what judges do. They've gone another step to say law is what judges actually do. And because you cannot predict judicial behavior with certainty, law is more art than science. So that legal realism school will say law is more art than science because law is what the judges do. Because we cannot predict how a judge will behave or how he will interpret a law, law is more art than science. So if I ask you a question such as, is law more art than science? You will now be trying to tell me these issues of what law actually is. That's the fundamentals is that to look into what law is. Is it a science in the lab? Is this sociological based? Is it this? Is it that? Okay. So law, as I've said, more art than science according to this school, and law will be influenced by experience, by policy, by values. So that's why if you're a judge, your decision making as a judge is determined by your background in many ways, yes. Your values, your social values, your religious values, your moral values, your policy, your experience. So therefore, in the case of an assault, where a stranger assaults a strange man, maybe assaults a woman, and a case where the stepfather of the woman of a woman or girl assaults her, the judge could be more. It could be much more. It could impose a higher punishment on the stepfather because they feel that someone that grew up as your own child, you are this wicked and this bold to damage this child. It doesn't mean that sexual assault by strangers is permissible. No, but those values those experience and policy comes into bear. That's why I guess when you go to gender units or whatever in Alausa, you find mostly women there because they're coming to bear. They're bringing to bear their views of what's happening in society. Now, you can have a more modern middle ground. You can have a more modern middle ground. So if you're a lawyer now, you say lawyer, you have a logical mind. So therefore, legal reasoning should be governed by logic. So logic is very important in legal reasoning. It makes sense. That's what makes sense. All men are mortal. Men die. John is a man. Therefore, John is a mortal. So you have a major premise. You have your minor premise. Reach a conclusion. So you're applying logical deductive reasoning. Okay. So when a client comes before you as a lawyer and says, I bought a land from John Adam's family. A month later, I went to the land. The land has been sold to someone else. You would be looking at not just the law, land use acts, and what have you. You'll be looking at the context of whether the people who sold the land even have a right to sell the land. You'll be looking at a larger picture. You see what I mean? Okay, and then you'll be advising the clients not just on the law, what is the land use act saying, but also on the realities that did you do your investigation? Which lawyer helped you buy the land? I didn't use a lawyer to buy the land. I decided to buy the land myself because lawyers are too expensive. Well, now you find that lawyers are actually cheaper because you now have to spend a whole lot of money fighting this matter in court. Okay, so we have to look at how our different approaches to what law is all about. So middle ground approach, you find that many scholars would say that law does have some scientific elements. It uses logical reasoning. It classifies uses classification, and it's also systematic. It uses systematic methods. But despite all of these things, law is not a natural science. Law is not a natural science. For them, they will argue that law deals with human values, human choices, and social purposes. And because it deals with all of this, it's not a natural science. And because of this, they feel that to answer the question, is law a science? They'll come to the view that, excuse me, law is better described as a social science and not a normative science. It's a science or discipline that studies how rules ought to guide human behavior. How rules ought to guide human behavior. Okay? So, if you are looking at law as a strict natural science, there could be disagreement on that point, even though there are elements of it that would gel with natural sciences. But at the end of the day, law is a science in its method, but it's probably an art when you are actually applying it. How are we doing? Have I lost you? Or have you lost me?
We're following you, sir.
We're following you, sir.
Okay. So that's why you should know the difference between law as a physical science, law as a social science. What is the process of scientific inquiry vis-a-vis how law operates? What are the different methods of discovery and validation? So those step by step, you should make sure you know it in your, what does legal reasoning mean? What does scientific reasoning mean? Do they mean the same thing? Or do they operate differently? One is in a lab trying to look at what they call in the inverted comma objective facts. One is in society, looking at how human beings behave. And that's why, because of that application to human beings, don't drink and drive. Don't do this. Don't do that. Don't slap your neighbor. Don't gossip. Is there a law saying you should not gossip? Hmm?
No, sir.
So you're allowed to gossip, so you're happy about that one. But what if you gossip and you say the wrong things, or you tell lies? Is there no legal recourse to that? What is that called?
Defamation.
Defamation. And it can be
Defamation.
proved.
Yes, defamation. Are you sure it's defamation? It's not called libel.
Libel is
Hmm?
under defamation.
Version.
What's the difference between libel and defamation?
So libel is a form of defamation. Defamation
Slander, not libel.
slander and libel.
What is the difference? Don't use Oyinbo against your teacher, which I went to school. What's the difference between defamation and libel?
Libel is published defamation.
Eh?
Defamation is like the umbrella body for slander and libel. So libel is the published one and slander is the spoken one.
That's what you say now. You say all this grammar. You say one is written, one is not written. Is that not what you're saying?
So it's like libel is necessarily a defamation, but defamation is not necessarily a libel. Because defamation can also be slander.
What course did you learn all of this?
Tort.
Okay. What year is taught? What year
Year
is
three.
taught? What year
Year-
is taught?
Year 3.
So you think you are still hot on all of this. Okay. So you are looking at human behavior. So if we can describe law as a social science, do you have arguments to say that law is not a social science? So these are things that you may want to bear in mind. Let's look at issues of what is law. We've said so many things about this and about that. So what is law? What is law? I think in the previous class, one of you was mentioning the fact that law is a system of rules. I think everybody more or less agrees to that. Law is a system of rules that a particular community or country adopts to regulate its members. Is that not so? Very well, broad definition. Law, you mentioned the Constitution, you mentioned legislation, judicial, court cases, stare decisis, administrative rules and regulations, local government, bylaws. All of this together will constitute basically a legal system. And that legal system will now be used to maintain and control social order. Okay? So I want you to go and look at HLA Hart's The Concept of Law. When I was in school, they asked us to go and read it. Well, your head goes scatter. You just be reading it and reading it and reading it. But by the time you read it for the 5th or 8th time, you now start to understand it. HLA Hart's The Concept of Law. So why are all these jurists that I've mentioned, philosophers, I mentioned Bentham in the past, I mentioned Austin, I mentioned Kelsen, I mentioned Hart. Why are their views different? Why are their views different? These different jurists. So I want you to look at it as to why their views are different. I want you to be able to compare and contrast the views of these different writers about the same subject matter. The one thing that you must remember always is that whether you call Bentham, whether it's Austin, whether it's Kelsen, whether it's Hart, whether it's any other philosopher, they are creatures of their own period of time or time periods, their own societies. That also, they're creatures of their own society, their own time periods. But when you analyze this, I always want you, when writing your notes, to always say to yourself, what is my own position? What is my own what? Position. Not Professor Ayoade's position. What is my own position? Are we good? In previous class, I mentioned what's jurisprudence, and we talked about the philosophy or theory of law. We're trying to understand what law is. How does law work? And what should the purpose of law be? And that's jurisprudence is one of the most debated issues when we're talking about why it's difficult to define what law is. So defining law is always going to be very difficult because law exists, as we have said, in society and so forth. So law is multidimensional. It's not just on a one lane. When you're talking about law, for instance, you cannot fail to mention the fact that it has social elements involved. There are institutions that are involved in law with the same issues of law, whether to promote it, whether to know what our obligations are, whether to punish it. We have various different institutions. We have politics. We have a political aspect to law because law is existing in society. So politics is part of it. I'd mentioned the Constitution. The way the Constitution, for instance, the way you approach law in a civil law society will be different from the way you approach law in a common law society. Can anyone, let me see if I can find any names. So we have 200 people, even though our class is 300 to 400 people. That also. Yinka Greg Oluwarotimi, are you around? Yinka Greg, are you around? Okay. So what's the answer to my question?
Sir, please, can you repeat your question again?
Because you're not in my class, why should I repeat my
No,
question? I asked you a
no,
question.
my network is not so good, so
It will
everything has
never
to be
be.
repeated.
It will never be good because you are not listening to me. I say I told you I know when people are listening to me or not. I'm going to repeat it on one off, and I encourage everybody else. I will not repeat my questions. If you're in class, you should be able to know what question I asked, and don't say network issues. I've been through this class before. I've been a lecturer for a short while. So what was my question? Me, I don't forget. Trying to castigate this silly boy. What's my question? No? Who wants to help me for that one?
You were asking about the fact that different societies they will have
They
different way
approach law
of life.
differently. Yes, we approach law
Yes.
differently. So there will be a difference between the way the civil law society will approach law and a common law society. So what will be that difference? That's my question to Greg.
Okay, so different societies approach law differently because they have different customs and traditions, and naturally, the customs and traditions of a place usually. My answer to that question would be, the customs and traditions of a people of a particular place or a particular country.
Yinka Greg, your mouth is sweet, but you're not answering my question. No. In the exam, you won't do very well because you're not answering the question. Gafa Kwawiya. Gafa Kwawiya.
Good
Where are
morning,
you?
sir.
Good morning. So, what's your own answer?
So I didn't hear that. The network like cut off.
Are you Kwawiya? Gafa?
Oh, okay. I didn't hear.
No, Gafa. So Gafa is not in class. Please make a note of Gafa Kwawiya. Svelana.
Sir, I'm in class. You were saying something, that's why I had not started answering.
Okay. So what's your own answer? You never answered the question, so I'm asking you the question to you.
I kind of agree with what he said about the fact that because they have different values
I know
and
we know there are different. One is civil society, civil law based. One is common law based. What is the difference? Was my question.
civil law systems. I think the main source of law is usually like legislation, like they have
Right.
written laws. Then for common law systems, I think they have a
You don't have
focus
laws.
on judicial precedents. I don't know.
That's the difference. One focuses mostly on the law, and the other one looks at both law and judicial precedent. Is that not the main difference?
Yes.
So you can have a magistrate in France that will do an investigation. It's not only the judge will ask questions and find out what actually happened. Unlike common law system, which is adversarial, where two opponents will come in and the lawyers will clash. I want you guys, I hope you guys are actually taking notes of what I'm saying, because there's method to the madness. So I'm telling you what to do. You should take notes and you should be working on how I'm approaching this. So another issue of why law will be difficult to define another difficulty is that law contains it blends facts and values. And that is, it is both what rules are and what the rule ought to be. So it's talking about both what exists and what values are. It's that combination that causes problems, because it's telling us this is the rule, and we're also looking at law as what it ought to be. So those two things I'm trying to mutually coexist in the same space. And that's why defining law will also be difficult. Also, different societies, as you both pointed out, have different legal traditions. So you must be able to see the difference between, say, Nigeria, where we operate different legal traditions. We are operating, Svetlana, what are the different legal traditions that we are operating in Nigeria? Russian Svetlana, are you here? Pen Ogbolu. I had mentioned that name earlier. I thought the person would be alerted since. Svetlana, are you in class? Mary Abuda, are you in class? Mary Abuda, are you in class?
Good morning, sir. I'm in class.
Thank
I'm in
you.
class. Sorry, my network was messy.
Yes, Svelana and her network, yes. Okay, Svelana, we'll start with you. Mention two legal traditions or legal types of law that we operate in Nigeria. Just mention two.
I think English common law
Yes,
and customary law.
fantastic. So, does the next person want to add to that?
Good morning, sir. We also operate statutes and case law.
But what's the difference between common law and case law? That's not, she told you that we operate common law. We operate customary law. What other law do we operate in Nigeria? You know now. Abuda. You don't know the answer to that simple question?
We also use
What about
our
Islamic law?
statutes.
What about
Yes.
Islamic law? Why are you repeating the same thing that they've already said?
Because Islamic law can also fall under customary law.
Sorry?
Islamic law can also fall under customary law.
Is it? Why do you have a Grand Cadi? You have a whole entire judicial system recognized by the Constitution of Islamic law, and you also have for common law, customary law as well.
Yes, sir, but some people argue that Islamic law is also customary law, depending on the area.
Well, okay, that's anyway. Another issue why it's not a single definition cannot capture the meaning of law. So you yourself expatiated on that. So we have different legal traditions, we have different societies, and common law, civil law, different types of religious law, and they all see law very differently. Okay, and then the works of different scholars who see laws. Some people say law is something is not a law if it's not backed by sanctions. Something is not law if there's no justice involved. If it's not the social control mechanism, it's not law. If it's not a class warfare, if there's no class warfare in it, it's not law. So the different scholars will approach law differently. And another thing is that law is evolving all the time. Law is changing. Law is not stagnant. It changes over time. That's why Polygamy is accepted in Nigeria, culturally, socially. Polygamy is against the law on the books. Yet we have judges that are polygamists and nobody's applying the law to them. So how should we not operate when we have things like that? Ume, Ezioke, Emeka, are you in class?
Yes, I'm in class, sir.
Yeah. So what should we do now in the situation which I've just described, where we say bigamy is against the law, but we don't enforce it? What should we do if we
Well,
believe
sir,
in the rule of law? Yeah, go ahead.
so I think it's contradiction. If those who are
Okay.
meant to law are also guilty of the
Yeah.
law,
Hey, but okay, how do we solve the problem?
I think it is by either amending the law to reflect our social dynamics
Norms.
or
Okay.
norms, or to enforce the law.
Simple. That's it. Very simple and very clear. Well done.
Thank you.
So different thinkers, different jurists will tell you how they choose, what they look at law as. I'll come again to the positivist school. We go back again to John Austin that we have mentioned severally. So you must know all the you should know these definitions now. Different definitions have come up over time. So you should know, because different people have described law differently. Okay. If you go to Cicero now, Cicero will say law is the highest reason implanted in nature. So Cicero has his own. Aristotle will describe as law as reason without desire. Holland, Hobbes, everybody has their own view of what law is. Okay. Now, John Austin, from that positivist schools we've been talking about, law is a command of the sovereign backed by sanctions. Law, to him, is a command of the sovereign backed by sanctions. So if we want to talk about law now, I underline law, command, sovereign, sanctions. So if you cannot, law equals command, there must be a command. If there's no command, it doesn't exist. If there's no sovereign authority backing it, that doesn't exist. And if there's no punishment or sanction for disobedience, it does not exist. So if I apply John Austin's view to bigamy, what then do we say? Does that mean that bigamy is not a law? The law against bigamy is not a law, because there's a law, there's a command, do not marry more than one wife. There's sovereign authority, federal government of Nigeria, but there's no sanction or punishment for disobedience. So what Austin is doing, of course, is not interested, those positivists have no interest in international law. They're not interested in custom or customary practices and social behavior. They're not interested in morality. They're not interested in politics. All those things that impact on law does not interest them. Then we also say law is a system of norms derived from a basic norm. There's a ground norm. Law is a system of norms derived from a basic norm. That's from the pure theory of law by Hans Kelsen, which I mentioned again earlier on. So for him, law is not a command, it's a hierarchy of valid norms. And each rule will derive its authority from a higher one. This approach of Hans Kelsen of hierarchy of norms does not consider morality to be an issue. Morality has no business in this. It's only concerned about whether those norms have legal validity. If the legal norm has legal validity, it's fine. If it does not have legal validity, not too good. Karl Marx define law as the will of the ruling class. It says the law is just there to maintain class hegemony, where the ruling class is oppressing the working class. And what the law does is the law protects the oppressor class. That's his own view. Okay. Ibukunoluwa Bajide, are you in class?
Yes, sir, I'm in class.
Can you be sent to jail for breaking a moral code? Or should
No,
we be able to send people to jail for breaking a moral code?
I do not believe so, because morals are, very different for certain people. Some people believe some things are immoral, while others disagree.
Okay, let's give a scenario. I hope I'm not being too crude, but it's kind of captures the complexities of it. There are two friends, and I'm not trying to be gender funny. It can be two boys or two girls. Okay, they're two friends, and one has the guy. His best friend has a girlfriend who is also his friend. At some point, it feels that his friend doesn't really appreciate that girl, and he would rather want to be her boyfriend. And he tries to engage with her romantically. Is there any law saying he cannot do that?
No, sir.
What if in this scenario, the two of them are brothers, blood brothers, same father, same mother? Is there any law saying he can't do that?
No, sir. As much as it sounds repulsive, I think
Yes.
saying that the law should be enforcing matters such as that may open up a can of worms.
Exactly. So if a younger brother or a senior brother takes over his younger brother's girlfriend and now marries her, nobody can take him to court. It's not a police matter, is it?
No, it's not. As long as the marriages are not concurrent. Even if they are concurrent, they're not enforced.
So if that's the case, this whatever sanction will come in for will be from maybe the family disowning the fellow. Abi, I
Yeah,
think
maybe
that's about the best that
public
can happen.
criticism about
Exactly. So that's why law is a formal process. Morality is more informal. However repulsive it is, it's still not a matter of jail. Now, I've seen, I read things in the newspaper sometimes where someone gets pregnant and the alleged owner of the pregnancy, I don't know how you say owner of pregnancy, but it's a Nigerian thing. So let me use Nigerian words for it. Is dragged off to the police station. Is it a police matter between consenting adults who are adults? But I've seen sometimes things like that in the newspaper. I don't know what the police is meant to do about that, but what do I know? Okay. So traditionally we talk about Yoruba customs and culture, talking about Omoluabi, a child who is well behaved, well mannered, a child who washes his hands will be able to eat with elders according to the Igbo custom. So every one of our societies believes that if you do well, if you do good, you should be able to mix with your elders, and everybody would be a winner. The natural law thinkers, which I also mentioned, I believe in the first class, natural law. Some of those natural law thinkers, like Aquinas, Cicero, Finis, look at law as an ordinance of reason for the common good made by one who has care of the community. For them, law has to reflect moral values. It has to reflect moral principles. It has to affect things like notions of justice. So for them, natural law thinkers, if a law is unjust, is not actually a true law. The problem with that kind of thinking is that it's incredibly idealistic. It mixes morality and people with law, and you don't know where morality is starting and legal judgment is beginning. So that's a school that you want to consider. The sociological definitions schools of Roscoe Pound and Ehrlich that we said earlier looks at law as a tool of social engineering or living law, because law is found in what society is doing. It's not just in the statute books. It's a tool of social engineering. So law is not what I will find if I go to LFN, laws of the Federation. Law reflects social needs, social wants, and practice, as opposed to only theory. The problem about that view is that, so you can see that every time I'm giving a view, I also say the negative aspects of it. So you must be able to just keep, this is what they believe. This is where the shortcoming of this particular view. The criticism is that, how do you distinguish between social norm and law? That boundary will be difficult to define if you keep saying law is not just in the books, it must be in practice. Who is to determine what that practice is? And when I go into the streets, what I see and what you see will be completely different. Are we together?
Yes, sir.
Yes, sir.
I keep asking whether we are together, but I don't know whether we are really together, whether you all know what I'm saying, whether you all understand what I'm saying. I'm getting worried because I don't want wahala. I hope you are following me. If you're not following me, when I remind you that the course jurisprudence is a compulsory course. It's compulsory. It's compulsory. Okay. So legal realists are talking about law in action, law, as opposed to law in the law books. Judges should not just consider the abstract rules. They should also look at the social relations, look at the culture. So if judges are looking at the culture and looking at the social rules, then bigamy should not be a problem. You know, because according to those rules, bigamy is not a crime. Yet it's an offense in the books. I mentioned the Marxists earlier on, Karl Marx, how law is an aspect of class conflict. And the law is the product of economic forces. It's economic forces between the oppressing ruling class and the working class who are being exploited. Okay? So for those ruling class to control the working class. And law, according to these people, will wither away sooner or later in a future communist society. Yeah? So I also mentioned the fact that when we're looking at aspects to doctrines of law, there's the imperative approach to law that says law is a command of the sovereign. I mentioned the fact that there's an institutional aspect to law where the prison service is there to punish? Is prison for punishment or reformation? Khadija Oguntade, I don't know what FM means, but I think that's fine. Khadija Oguntade, are you in class? Leader, very interesting name, Leader. Or is it a nickname? Are you in class? Khadija is not in class. Leader is not in class. Miss Toras or Shunuga, are you in class? I hope my class
Yes,
rep is
sir.
writing down the names of all
Yes,
these people.
sir. I'm in class.
Okay, Oshunuga, thank you for being in class. You are trying. You should get an award for being in class. So what's prisons for? Reformation or punishment.
So I didn't get that. What is what for reformation?
Prisons. What are prisons for? Nigerian
Oh,
Corrections
okay.
Service.
Okay, seriously, because I try to reason why people are being sentenced, but I think the common view is going to be is for reformation. Probably they would learn lesson and all, but I
Go ahead.
I don't think it is actually getting what it is meant for, because you see people go to prison and come back and still do what they've been sent to prison for. It's not fulfilling what is actually meant for.
Is prison is it not also supposed to be deterrent? Is criminal law also not supposed to have a deterrent effect?
Yeah, it has a deterrent effect, but
Yeah.
on the long run, people are different. Why some people would deter from it, that oh, I went to the prison and I would not do what I was sent to the prison for. Some other people will still go there. It's not just to go to prison. So it is not generally serving the purpose on the long run, because some people would not still deter from what they've been sentenced for.
Okay. Love the point. Now, I'll be honest with you. I used to be, when you stay too long in Europe, it's a problem in many ways. But I'm coming to the view that I prefer flogging and caning that they used to have in colonial times to prisons. I'm coming to the view that for misdemeanors, locking somebody up does not add anything to them. You're actually going to expose them to hardened criminals who mess them up. Most of our population in jail are on remand, meaning that they've not been convicted of anything. So, accused of stealing a Nokia mobile phone of 10,000 naira, 2 years later, still in remand. Even if you had been convicted of that offense, it's not going to be up to 2 years now. Why not give them options to say, look, 2 years in jail, or you spend 2 years waiting for your remand if you wish, or 10 strokes of the best on your back to teach you that next time you respect other people's property and what have you. I think we may need to revisit things that we now say, oh, it's against human rights, against it's torture, it amounts to torture. But if in a poor society where people are so desperate, is quick justice not what is needed as opposed to further ruining their lives by keeping them endlessly in cells? I don't know. I'm just raising the point for you to. That raises the point as ethical aspects of law. A law requiring flogging, is it a moral law? Peace. Babalola, I think. Babatola.
Yes,
Peace,
sir.
Babatola. Are you here?
Yes, sir. Can you hear me, sir?
I can hear you. What's your view? You can't hear me now. Yes, who has their hands up? I can see a hand up here.
Good morning, sir.
Yes,
My name is Shida Injola Mekose.
go ahead.
So I have a view of prison being a reformative or depriving. So basically, what prison does is that it's just depriving people of freedom and
Okay.
keeping them in solitude. So I think
Okay.
that it works in two ways. Why some people will have a reflective time doing when they deprive them of their freedom, and it's not like, oh, they are apparently going to be in a confined space, just them, whereby they can process their thoughts and process, oh, what made them do this, what made them do that,
Okay.
because they are going to mingle with people of all sorts, like you said, both the hardened criminals and everything. I think abroad there's this thing they do whereby they put you in a solo space whereby it's just you. They can do
Solitary
shit on.
confinement.
Yeah,
Do you know
yes.
how expensive that would be to build thousands of individual units for one person?
That's why I'm saying that. I mean, if that's the kind of thing we have here, maybe it will do a better it will serve a better
Job.
purpose of reforming
Yeah.
people, because they
Yeah.
will be left to their thought alone and they will have time to
Okay.
process it. But once you are exposing them to people of different views and all of that, I think that they're just going to learn how to be better at whatever they did that brought them there. They will be better
Okay.
at being a better criminal.
Okay. Fair enough. Fair enough. Now, if that's the case, do you, Olamiposi, prefer flogging as an alternative to imprisonment? And if so, is it ethical to flog in terms of morality? Go ahead.
Okay, so flogging might not be the instant thing, but I feel like instead of setting out a long time for punishment, there should be varieties of judgment that can be passed immediately. Like for those that rape, you can cut off their manhood and all of that. Like let them.
Congratulations, just like that.
No,
Is that
I
not
feel
against morality?
no, I feel like no, I know, right? But like along the line, it will deter people faster than when they have a long
May
rope
I
of.
ask, if you cut off something or you execute somebody, and then you find out 2 weeks later or 10 years later, the person confesses that actually I lied.
No,
How
that's
do you
after thorough
how do you
investigation,
restore
though.
what
That's
has
thorough.
been?
That's after thorough investigation. I mean, not immediately, but like after, instead of
There is no thorough investigation that is not compromised. Police officers can be corrupt. People lie. You just can't tell. That's the truth of the matter. So we have to be very careful about permanent damage, if you see what I mean. That's why sometimes that's the argument against executions and sentencing people to death. That it's final. There are people who live in jail in America after 40 years, vindicated completely that they were completely innocent. Completely, not even maybe. DNA testing advances has been able to release many, many people. In Nigeria, we don't keep any records, we don't keep any DNA tests. People just die for nothing. And, we are where we are. Okay. I mentioned the fact, I want you guys, the names of people, the class rep should mention note of this. Those names I mentioned of people who are not in class, when I called for them to answer questions and they never answered, they're supposed to go and find me individually and collectively. They are responsible for finding me Taslim Olawale Elias's inaugural lecture, Law in a Developing Society. They should go and look for it. Go to the library, go wherever they want to go and look for it. They must get it for me. And I think the next class is on Monday. I want to hear from you that they already have it. If it's a physical copy, you snap it and send to me, or you scan it and send to me. That's named Olawale Elias, Law in a Developing Society, was an inaugural lecture delivered at the University of Lagos in January 1969. Class reps, did you get what I said? Confirm.
Yes, sir.
Thank you very much. So I've been talking about how everybody has different approaches. John Austin, law is a command of the sovereign, and so forth. So you must have laws. It will also say something like laws are commands issued by the uncommanded commander. I know you like things like that. I always see that all the time. People love writing that rubbish down. Laws are commands issued by the uncommanded commander. The uncommanded commander being the sovereign. And such commands are, of course, enforced by sanctions. And the sovereign is the one that is obeyed by the majority. So for Austin and people like that, law is a rule laid down for the guidance of an intelligent being by an intelligent being that have power over him. Okay. Austin Hart. Look at what Professor H.L.A. Hart also says. Okay. So some of the key approaches to defining law, as I've mentioned again, is coercion. Look at authors like Austin and Bentham. We'll talk about coercion. Social contracts approach to law. Look at Hobbes. Look at Locke. Look at Socrates. Look at Rousseau. Law has no obligation. Look at the Razian analysis. Law approach considering issues of integrity, the moral integrity of law. Look at Dworkin. You can see that I've mentioned more than about 10 different writers and jurists and philosophers. So you need to have each of these people in mind. So law in reality would follow customs, it follows practices, it follows, regulates conduct, regulates how we approach finance, how we approach crime, how we approach civil cases. You know, people like Cicero, law in the proper sense is the right reason in harmony with nature, because they're naturally, they need to come from a nature school. Blackstone, a rule of civil conduct described by supreme power in a state commanding. Everybody has their own little approach. Even Thomas Hobbes, the father of law and literature. Thomas Hobbes is known as the father of law and literature. Thomas Hobbes, so you know his name. He looks at law as a command addressed to one formally obliged to obey the commander. You must obliged to obey the commander. And law is the formal glue that holds fundamentally disorganized societies together. You know of Hobbes, how he believes that human beings are fundamentally disorganized. So law is that glue that would hold society together. H.L.A. Hart defines law as a system of rules, primary and secondary rules. The primary rule governs conduct, and the secondary rule allows for creation or modification or review of that primary rule. Bentham, all of these people I've mentioned, natural law and positive schools, you know, legal realism, you know. Glanville Williams, very important, Glanville Williams. Glanville Williams talks about law as the cement of society and also an essential medium of change. Knowledge of law increases one's understanding of public affairs. Its study promotes accuracy of expression, facilitating argument and skill in interpreting the written word, as well as understanding social values. In that classic book, Learning the Law. This is a book that was published first in 1945 and been reviewed subsequently. So you have to ask yourself this fundamental question. You have to ask yourself this fundamental question. Is law dependent on culture? Is it dependent on your worldview? Is it dependent on your background? Should it be? What's your view? What do you think? So law can be elusive in nature. Law can be elusive. Law can be elusive. You have to look for law. It's complex. It changes over time. There are different perspectives, different authors, different views. There's the issues of overlap with morality and politics. So you can't consider it as a fixed thing, because in many ways it's moving around. It's a living organism. Law as a living organism. Law as a living organism that reflects morality, social conduct, politics, religion, whatever. So each definition in reality only captures a part of the reality of law. That's why jurists will continue to debate the nature of law from today to tomorrow. So what is law? What is law? That question has always been with us. It's not a new question. And it's still with us till today. We're still battling issues of that people battled in the 19th century, battled in the 20th century. In the 21st century, we're still saying, what is law? When people are saying law is an embodiment of reason, whether in the individual or the community, law is an embodiment of reason from the natural school. You know? Are we good? Are we good?
Yes, sir.
Yes, sir.
I have this view that whenever I say are we good, you have no choice. You have to say yes. Like it's gunpoint. So evaluate the different schools. Evaluate, you should be able to tell me what not less than 10 different authors say about what law is. You should be able to say it. I mean, easily. Law is the command of the command uncommanded commander. Law is this, law is that. The Marxist school, natural school, positivist, realism. Are we good? Yet again. Okay, if we are so good, Salami Samsidin Olakunle, are you here? Are you here?
Yes, I'm here, sir.
Are you sure?
Yes, sir.
Which of those laws do you like? That approach or definitions do you like and why?
I can say it from
I can't hear you.
the
Sorry?
sociological perspective.
You prefer the what?
Sociological.
What? Okay, what is the sociological perspective or sociological approach to law? What is it?
The approach is that law should be applicable to the fundamentals of the society. And if it's not applicable to what the society entails, it means it is defective.
So why do you like it?
Because it correlates with what is happening in society, and there's a way of harmonizing the societal beliefs and the tradition with what law, so that there won't be contradiction between law and the belief of society.
I have to be honest, I'm struggling to really hear you because the network is really bad from your point of view. Okay, so let's read up on the view of our esteemed Professor Elias on that law and social change. Very important that we look at it. Looking at how law is, what are the ways we can look at that definitions, the different ways. We can look at it as a nominal way. We can look at it as a conventional way. We can look at it as a real or essential or intrinsic approach. Different approaches will come out. Okay. Zenith Nwani. Zenith. I don't know whether you own Zenith Bank. Are you here? Zenith Nwani? There's someone that describes themselves as Zoom user. Can I respectfully urge you to change this kind of funny names? You should not be, this is a working environment. You should not be called Zoom user. You Zoom user or magic number. That's not your name. You
Yes,
should have
sir.
your name there. Who is
Hello,
speaking
sir.
now? Yes.
Sir Zenith. Good morning, Sir Zenith.
Zenith. Okay, Zenith Wani. Welcome. What's your own favorite approach to law?
I think I agree with the realist school founded by Oliver Wendell Holmes.
Okay.
Because in
Which is?
reality, at least in Nigeria, and we practice the common law.
Okay. Okay, what are the weaknesses of your position?
So, sorry, I believe that in Nigeria, where we practice the common law system, our laws are case-based, and the judges technically like create the law. So the bad man is not necessarily concerned with what the statute would and contain, but in reality, it's what the judges say or what they interpret the law to be. That is the law. So I feel like that is the most pragmatic school of law, at least.
Okay. All right. I think we are getting there. Are there any other issues that we want to look at? Are we good to go? Are there any questions, comments, perspectives?
Okay, I have a comment. I have a
Okay.
perspective. Okay.
Go ahead.
When you ask the question on the difference between the civil and common law, basically, my perspective is in the application of law, you can also see the difference. Where in civil law, they have a jury, they kind of democratize the process. They involve the layman in determining what is right or wrong. In common law, this is just left to a judge or a few judges at best. And seeing as that forms a part of the law, it forms case law, I'm not sure it might be the best way to go about things, because we're kind of limiting the scope of things. Like, we're limiting it to their own moral compass, their own views on stuff, their own values. So I think we need, like, I mean, of course, in alignment with general principles of justice as well. But then sometimes their moral compass still affects their judgments, and then we end up taking up these judgments as part of our law. So that's my comment.
Thank you very much. Zoom user, are you in class? Zoom user, identify yourself. Are you in class? Yes or no? Because if you've typed in that you're in class, that could be difficult. Zoom user, for the final time. Okay, Zoom user has refused to identify themselves. Is Zoom user in the chat box? Because the name of the Zoom user will be in the chat box. So I don't know why you are trying to say you're not in class. Because you won't get credits for attending. Okay, I saw a comment here that solitary confinement is not helpful. It leads to mental trauma most of the time. Actually, it does lead to mental trauma. A lot of people who do it come out nuts. Because if you don't, human being is a social animal. And if you exclude him from other social animals, it starts to go crazy. So it's actually a punishment. It's a severe form of punishment. Solitary confinement is not a recommended way of imprisonment. It's not. It's actually used in extreme cases to punish recalcitrant and prisoners who are a threat to themselves and they're a threat to society. So I mentioned Hobbes. What is Hobbes well known for? What's Hobbes well known for? Hobbes yeah, go on. There's a particular phrase that Hobbes is well known for.
The society without law is nasty, petitioned. Short.
Yeah, basically, the view is what you call the Hobbesian state of nature. It defines nature as basically, if you don't have government or laws, it will be war of all against all. It will be anarchic. it will be a war zone. Life will be solitary, but we didn't talk about solitary confinement. Solitary, poor, nasty, brutish, and short. So life without law will be solitary, poor, nasty, brutish, and short. Because he was of the view that that kind of society where there are no laws in place to checkmate the brutal desires of man, then there will be conflicts for resources, there will be lack of trust, and there will be obsession with achieving one's aims over others. Okay? So to avoid this constant fear and conflict, Hobbes' view is that rational people or rational individuals should enter into a social contract whereby they surrender their natural rights to an absolute sovereign, a leviathan, in exchange for getting security and order. So rational beings, to avoid this Hobbesian state of nature, where life is solitary, poor, nasty, brutish, and short, should surrender their natural rights to an absolute ruler or sovereign, the leviathan. And what do they get in return? They get security, they get order. Okay. So for the three elements for him is to escape that state of nature. Is the social contract, is the surrender of rights, and the fact that it's an absolute ruler or leviathan who would now collect your power and sovereignty and give you peace and order in return. Okay, I think we have come to the end of the class. There have been no questions. Thank you so much. We will convene online. I've told you I'm going to be traveling and I'll be moving from place to place, so it could be difficult sometimes, but we'll try and make it work. Okay, so you have your course outline. Go and start reading on law, morals, and religion. It's really very interesting. I want us to make it exciting and, enjoy the course. All right. Someone's laughing that they don't enjoy jurisprudence, but no problem. Wish you guys well. Have a wonderful rest of the day. Bye-bye.
Thank you, sir.
Thank you, sir.
Bye, sir.
Bye.
Nice.